Good morning. This is Rich Sierra, President of Florida Small Business Legal Center. This is episode number 38 of Business SOS. Thank you for listening. Thank you for following the show. I'd like you to participate in the show. If you have a legal question that you'd like to ask me, you'd like me to go over in the show, please send me an email at rich@richsierra.com. And if I select your question, your legal issue that you have, you want me to discuss, I'll send you a free copy of my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. It is available on Amazon, Barnes & Noble. You can ask for it in your local bookstores. Today, we're going to talk about employer independent contractor. A very important topic because it's a brand new law that just was passed in January 9th, actually January 10th of this year. It's a new regulation by the U.S. Department of Labor regarding the Fair Labor Standards Act. Why is this important? Sometimes talk to some of my clients and I ask the question, do you have any employees? And they say yes, but I also have independent contractors. And the common term that I hear is I have 1099 employees. And I said, what does that mean? Well, they kind of work for me, but I just pay them as independent contractors. And my answer is that does not exist. There's no such thing as a 1099 employee. Okay, they are either independent contractors or they're employees. And let's talk about that definition. What happened in January 10th is that the Department of Labor redefined how a quote unquote employee or person working for you as the business owner is basically classified, whether it's an employee or independent contractor. So what they did with the new rule is they made a more expansive definition, meaning that it is more likely that somebody working for you will fall in the category as an employee. Why they did this? They did it because they want to make sure that employers pay their fair share of payroll taxes, and also that the employees get the unemployment compensation, they get the benefits. The benefits nothing to do with the salary, but the point is they don't want employees circumventing wage and hour laws in an attempt to not pay payroll taxes. So that's what we're going to the definition here. So what they did now is they created 6 different categories of what they will consider different criterias. And I'll go over them briefly, and I'm getting this information, and I'll tell you exactly where I'm getting them from. It is from a Department of Labor Wage and Hour Division, frequently asked questions, final rule, employee or independent contractor, classification under the FLSA. And this is just a fresh information based on a new ruling that came out on January 10th of this year. And I'm not going to go through all the questions and answers, but I'm going to read some of the important information that will affect you as the employer if you currently have independent contractors. And the reason I'm sharing this with you is that if you have independent contractor agreements right now in place, it might be a good idea to contact your attorney and say, listen, I have these people that are independent contractors. This is a brand new rule that came out. How does that affect me? So you have to basically take a look again at those independent contractors that you have. Look at, they could have been properly classified under the prior rule that was passed in 2021, but under the new rule, they might not be considered independent contractors. So you have to kind of take a look at that again and look at it and make sure that you're in compliance. Because if you're not, there could be significant consequences. The final rule is effective on March 11, 2024. And since this is a brand new rule, there are already court challenges in federal court, but some companies challenging whether or not this particular rule is ambiguous, whether or not it's arbitrary. That's for a different topic of discussion, but there's some rules. There's some challenges in federal court as to this particular law. But as of now, the final rule is going to be effective March 11, 2024. So this is an opportunity for you to do a review of your independent contractor agreements, review of who's working for you, and if you're paying your employees as a 1099, or someone working for you as 1099, quote unquote, independent contractor or employee, you need to take a look at this to make sure that you're in compliance. So one of the things to look at is the opportunity, and I'm going to go over each of them individually. The substance of the final rule, and I'm going to actually read some of the material here, is important. One of the questions is, what analysis guides whether a worker is an employee or independent contractor under this final rule? And the answer is, this final rule continues to affirm that a worker is not an independent contractor if they are, as a matter of economic reality, economically dependent on an employer for work. Consistent with judicial precedent, the Department of Interpretive Guidance prior to 2021, the final rule applies the following 6 factors to analyze employee or independent contractor status under the FLSA. Number 1, opportunity for profit or loss depending on managerial skill. Number 2, investment by the worker and the potential employer. Number 3, degree of permanence of the work relationship. Number 4, nature and degree of control. Number 5, extent to which the work performed is an integral part of the potential employer's business. And number 6, skill and initiative. What is important to know here is that when they analyze these 6 factors, and there's also one more, it says any other factors. So it's very broad. In my opinion, it's a very broad interpretation, a very broad ruling, because really it's kind of a catch-all provision that you really do not know, and it's really hard. It's more of a default provision that is more likely than not that somebody working for you might classify as an employee and not as an independent contractor. So we'll go through them, most of them, all of them individually. So one of the things that they look at here is that if the quote-unquote independent contractor depends on their income depends primarily on your work, on your type of work that you're doing, for the type of work he's doing for you or he or she is doing for you, then it is very likely that is an employee, even though they're paid as an independent contractor. So that's what they call the economic reality, being economically dependent on an employer for work. So if this independent contractor, let's use an example, is a freelance copywriter. And this copywriter does press releases for you, do blog posts for you, exclusively. You give them hours to work, say 9 to 5, even if it's 3 times a week. This copywriter does not work for anybody else, only works exclusively for you. And say they cannot work for anybody else, and you're paying as a 1099, it is likely that it's going to fall into the employee category. If this freelance copywriter does a press release, say once a month, but also this copywriter has other clients as well, and he or she does not depend on you primarily for his or her income, then it is likely that will fall into the independent contractor category, especially if this copywriter has her own business. So I'm also going to give you that as a very top-line example regarding the opportunity for profit or loss depending on managerial skills. That whether or not that employee is dependent on you, that person depending on you primarily for work. Another important factor here is that sometimes I get comments from some of my clients, well, I have this employee, but he wants me to pay him as a 1099 employee so he can have save some taxes. And my answer is don't. That's right off the bat. The employee cannot waive the provisions of the Fair Labor Standards Act. The employee doesn't have a choice here in how he gets paid. It's not an option. It's not an optional thing. It's either if the person is an employee, they have to get paid as an employee, especially if they have regular hours. You provide supervision, you provide the tools, you provide the equipment, you provide the training. That is an employee. And I want to emphasize that the employee doesn't have a choice here, and it's not an optional, like a checkbox, would you like to be paid as an employee or independent contractor? There are really no choices here. It's basically the classification is your responsibility as a business owner. It is also your responsibility to be familiar with this to make sure that you don't fall into any inadvertent mistakes. And the whole premise of Business SOS is avoiding mistakes. And this is an avoidable mistake. And if you have any questions about the classification, you can talk to your CPA, you can talk to your attorney who understands this issue to make sure you don't get into any problems later on. And that could affect you. And I'll just give you an example, a two-way, how this can affect you. Say you pay an employee as an independent contractor, but it's actually technically an employee. And the person has an accident or falls in your premises. What's going to happen here is that the insurance company is going to be asking questions and say, well, what happened here? I mean, were you working at the time? Yes. So then that's going to trigger a workers' comp claim. You're going to say, well, independent contractor, I don't have to pay workers' comp. What's going to happen, you may end up being the receiving end of a lawsuit by that employee because you're supposed to have workers' comp if you have more than 4 employees. My recommendation, even if you have 1 employee, you get workers' comp insurance. But I'll give you another example how this could happen. Say you have a falling out with this independent contractor, quote unquote, okay? So, and there's an issue of wages. There's an issue that a dispute as to how much money this person is owed. Person goes to an attorney, and then the attorney is going to ask these questions. You know, are you an independent contractor? What were you doing? Were you required to show up to work, at a specific time period? Yes. Were you supervised? Yes. You had responsibilities in the job? The answer is yes. Okay. Were you provide your own tools? No, I just went there and I got everything that's provided for me. Did you receive any training? The answer is yes. Guess what? You're an employee. How long have you been working with this employer? About 5 years. Okay. Guess what? That attorney most likely will recommend a potential wage and hour lawsuit against you as the business owner for possibly failure to pay overtime, failure to pay the wages, and failure to withhold taxes. There's so many. So you have a wage and hour law retroactively, and a wage and hour laws, whether it's a Florida, the wage and hour law, or the federal one, it's a really pro-employee statute, meaning that if the employer does not have very detailed records of the amount of hours, the time that the person worked, how much was paid, assuming that you overcome the issue of whether it was an employee independent contractor, okay, that's the first hurdle you got to cross. It is assumed that the employee was right. And then you can end up paying significant amount of money, not only to the employee for back wages, but also in these statutes allow for attorney's fees to be paid separately. So a lot of attorneys accept these cases because their attorney's fees provision that they can actually collect from you, the employer, and they have to be approved by the court. And there's a law firm that specialize only on these cases. So to save a few dollars in taxes and payroll taxes, is it worth the risk of having a potential wage and hour law violation lawsuit against you? You make that choice. My answer to that is no. If you have an employee, pay them as employees. You want to pay them bonuses, that's fine, but do not circumvent the wage and hour laws because it will come back to haunt you. It could come back to haunt you later on And usually it comes back to you at the worst possible time. It's just a ticking time bomb that later on could explode. It's just not worth it. So I just want to give you that piece of advice. The other factors that they consider here on this page, the investments by the worker and the employer. Okay. One of the things to look at, so the employee provides their own tools. The employee is investing money in his or her business versus, you investing in your business. And I have to agree that this particular category, it is not very clear. But the way I understand it is like, listen, this employee has his own business that he's marketing out there, getting other clients. That's basically one of the criteria to look at. The degree of permanency of the job relationship. That would mean how long has the relationship been going on? If it's an ongoing relationship, meaning that the employee or this independent contractor has to show up to work Monday through Friday, 9 to 5, specific hours. Most likely, this is an employee, even though you're paying this independent contractor. If the work is like an assignment, say, you're going to cover, it's going to be a temporary assignment, a week. The person is covering for someone, possibly. But they look at how long is this relationship. If it's a one-time assignment, if it's sporadic, if it's like, for example, the example that I gave earlier, you're going to write a press release from me once a month. You do your own thing. I'll give you the information. A photographer, web designer, social media influencer, anything that is, they can actually have other people working as well, that they have other clients. That falls more independent contractor versus the employee. So from what I read in these rules, is like the default is like an employee unless you're able to meet all these different criteria. So it is an opportunity for you to reevaluate anybody who's working for you as an independent contractor. If the person who works on commission sales, you have to look at that as well. And you got to have proper contracts as to the type of contracts they will have in terms of being in commission. Another thing that they look at is the nature and degree of control. How much control does this employee have over their daily activities? So is the independent contractor can come in and go as he or she pleases, or does it have to be a specific time period? If it's something you have say a distributor, somebody selling your product, and it's simply a licensing that the person can sell at any time, they don't have to show up to the office. They just basically sell and they get commissions whenever they want to do it. And there's no requirement for them to show up to work. There's no quotas. There's no, who has control over that relationship? Is the employer who has control over the person's time, or is the independent contractor has control over his or her own time? So they'll look at that as well. Degree of supervision. Is the person being supervised by the employer, and how much supervision? If the person has any managerial duties as well. So do look at that as well. And again, this is a brand new, so I cannot give you a lot of different examples because it's a brand new law. So there are not a lot of examples provided to us, unfortunately, in this handout. One thing that is important is whether or not this particular employee is an integral part of the employer's business. So in a small business, you have key employees. It's common because, you're small and you rely on, so you have 2 or 3 employees. So usually have 2 or 3 key employees, or one key employee that manages everything or helps you out. So that is an employee for the most part. But if you're paying that person as an independent contractor, and that person is an integral part of your business, meaning that if that person is out for a week, your business will really be in trouble. It is likely that person is an employee. So if you're paying that individual as an independent contractor, you have to take a look at that contract-like relationship and talk to your attorney and make a determination on whether or not that is the correct approach. One final point I want to make is basically skill and initiative. The more specialized this independent contractor is, the most likely he'll fall independent contractor area. And I'll give you, for example, now tax season is coming up. So you have an accounting firm, you hire another CPA to help you with taxes, and you basically you hire basically more of a contract type worker, and the person is sent out taxes to do on his or her own, send them back. That most likely for independent contractor because it's really more of a task, it's an assignment versus a job. They're just doing it for a temporary basis, and it's highly skilled, and it's likely falls under that category. So this is kind of more of an overview. Just my point today, if you have a takeaway here, is that if you have independent contractors, you have independent contractor agreements, review those contracts, review those relationships, talk to your attorney, talk to your CPA, and of course, we're very happy to help you as well. So that is all for today. Just to want to give you a recap, make you aware of this law that's just going to become effective March of 2024, March of this year. So please be aware of it. If you want to reach me, again, at rich@richsierra.com. You want to learn more about our legal services, my website is floridasmallbusinesslegalcenter.com. We're at Facebook at FSB Legal. We're on YouTube at youtube.com/Richard Sierra. We're on X at Rich_Sierra. We're on Instagram at FSB Legal. If you want to call us and you want to have any questions specifically about this as well, about whether or not you have employees independent contractors should be employees, we're happy to help you as well. Our number is 866-842-5202. Remember that Business SOS, 8 common legal mistakes business owners make and how to avoid them. It's available on Amazon, Barnes & Noble. You can ask for it at your local bookstore. Remember to follow us on Apple Podcasts, Spotify, wherever you enjoy your shows. If you like the show, please follow us and give us a review as well. 5-star review. Until next week, this is Rich Sierra from the Florida Small Business Legal Center. Remember that my goal is to help you succeed.